to 55916. So I was talking about the facts of the case and the issue that has been discussed in this case. So for the facts of the case is the respondent filed an action against the appellant due to the failure of the appellant to repay a short-term loan that has been entered between them. The respondent applied to serve process out of jurisdiction at the address of the appellant in South Africa. Later, the respondent informed that the writ and summons has been served to the appellant. Because of the failure of the appellant to enter appearance and defense, the respondent entered judgment in default. So the issue in this case is whether the judgment in default that has been obtained by the respondent was an irregular judgment or not. So the Court of Appeal judge stated that the judgment in default cannot be considered as a regular judgment because the respondent failed to produce a certificate that required under Order 11 Rule 5 Clause 5 of Rule of Court. The respondent only relied on the email that has been sent by High Commission of Malaysia in South Africa as the certificate. However, Court of Appeal judge stated that the email cannot be considered as the certificate required under Order 11 Rule 5 Clause 5 of Rule of Court. Thus, the judgment in default that has been obtained by the respondent was an irregular judgment because of the irregularity of the service of the rate. Thank you.
Hi, my name is Yuvashana, metric number 252674. Okay, moving on to the arguments by the appellant and also the respondent. First, the appellant contended that the judgment in default obtained by the respondent was irregular in respect of the service of writ. The appellant argued that the writ should actually be served personally to him and not to his residence according to the Order 1, Rule 10 of Rules of Court. Next, the appellant argued that the email tendered by the respondent was vague with no acknowledgement. Referring to the email, there was no proof of service document furnished by the sheriff or the process server, and the only proof of service is the sheriff's written by referring to the South African Uniform Rules of Court. Next, the appellant contended that the learned judge failed to appreciate the burden of proving that the service of writ which was affected lies within the respondent in the event of service out of jurisdiction. This means that the respondent who argued that the service of writ was affected should adduce the evidence accordingly to prove that the writ was served on the appellant in accordance with the law of South Africa. Finally, the appellant contended that the loan agreement concerning a money lending transaction with the respondent was void as it was contrary to the Money Lenders Act 1951. For instance, the appellant was asked to mortgage the house as a security even though the money was received in installments. Next, the arguments by the respondent. Firstly, the denial of the appellant regarding the knowledge of the service of writ and judgment in default was invalid as the appellant admitted that he received those cost papers in the affidavit in reply and appellant had attached the judgment in default in the email sent by the appellant. Next, the respondent contended that the service of writ was regular and effected on appellant based on several grounds. The first ground is that the writ does not need to be served personally, but as long as the writ is served on the appellant in accordance with the law of the country. In this case, the service was successfully served as there was letter issued by the Deputy Registrar of High Court of Sabah and Sarawak, and the cost papers were served at the address of the appellant. Then the Council of Respondent also contended that the said email was an official certificate which falls under the definition of Order 11, Rule 5, Paragraph 7 of Rules of Court as it had accepted as certificate by the consular officer and the form of certificate by a consular officer which was not prescribed under the Rules of Court. It was further argued that the authenticity of the said email was not challenged by the appellant at the first place. Lastly, the respondent contended that the appellant failed to enter appearance and defend within the time limit even after the defendant was aware of the writ served. Therefore, the judgment in default entered was regular and effective. Thank you.
Waida Azriana binti Azman 255796, and I'll be explaining on the summary judgment of this case. As been mentioned before, this case was brought before the Court of Appeal as the defendant was unsatisfied with the decision made by the High Court as well as the Deputy Registrar. In this case, the Court of Appeal agreed that the judgment made by the High Court was in fact contained error, therefore they have the right to intervene. The Court of Appeal stated that the High Court failed to consider the real meaning of official certificate under Sub-Rule 6. In this case, the judges of the Court of Appeal referred to Oxford Advanced Learners Dictionary as well as Osborne's Concise Law Dictionary to refer the real meaning of certificate. The Court of Appeal judges stated that the email shall not be accepted as a certificate or official document after reference has been made. In addition, the email also did not mention or stated any of the two alternative confirmations under Order 11, Rule 5, Clause 5. Here, the judges of Court of Appeal reaffirmed that the service was in fact irregular on the ground that the email that the plaintiff claimed to be the official certificate does not mention any of the two alternative confirmation mentioned before. Thus, the email cannot be regarded as an official document under Order 11, Rule 5, Clause 5 of ROC. In conclusion, the judges in this case agreed that due to the fact that the judgment in default made was proven to be null and void on the ground of illegality or jurisdictional error, therefore it has to be set aside and the defendant has the right to set it aside.
When leaves out things, I will continue on the part of analysis of established law. So service of jurisdictions is when the plaintiff wants to serve the writ to defendants who reside outside the jurisdictions. So the leave must be granted from the court before the writ can be served out of jurisdictions as pursuant to Order 11, Rule 4. So in Malaysia, there are two modes of service of the writ. First is to serve on defendant personally, or second, send to defendant last known address through AR register post. It was clearly stipulated under Order 10, Rule 1, Sub-Rule 1. So Order 11 is regulate the service of the jurisdictions. So Order 11, Rule 5, Sub-Rule 1 is applicable when the service of the writ is out of jurisdictions. It clearly stipulated that Order 10, Rule 1 is subjected to Order 62, Rule 5 and Order 11, Rule 5, Sub-Rule 3, where under Order 11, Rule 5, Sub-Rule 3, it clearly stated that the writ need not to be served on defendant personally as long as it were in accordance with the law of the country in which the service was effected. So in this case, the counsel of the respondent relied on Order 11, Rule 5 and Sub-Rule 3 to argue that the service of the writ was regular, as the writ need not to be served on the appellant personally as long as it was served in accordance with the law of South Africa. So next, to prove that the service of the writ was effective, an official certificate must be produced. So the official certificate must be stated that the service of the writ is either be served on defendant personally or served in accordance with the country in which the service was effected. It was clearly stated under Order 11, Rule 5, Sub-Rule 5, Sub-Rule 6, and Sub-Rule 7. So in this case, the respondent argued that the email issued by Third Secretary of the Malaysian High Commissions and an official certificates. However, the Court of Appeal rejected these contentions. This was be further explained by Long Xiang later. So in this case, the email did not state that the writ has been served in accordance with the South Africa, because there's the strict compliance with all procedural and substantive requirements in order to serve the writ of a jurisdiction effectively, because it's an encroachment of the state when the writ is to serve to the states. In other words, the judicial power of one state cannot be extended or exercised in another independent state, except with the consent of the state. Therefore, the law of the state in which a country is to be effected must be strictly complied with. So in this case, the respondent failed to produce an evidence to show that the writ has been served in accordance with the law of South Africa, so that the court held that the service of the writ was irregular and the judgment in default could be set aside.
Thank you, Ms. Shikin, for her previous presentation. Now we are going to analyze the judgment given by the courts. Firstly, we agree with Court of Appeal that there was no proof of service of writ because the official email tendered by respondent does not constitute a certificate as per required by Order 11, Rule 5, Sub-Rule 5. Such email could only prove the process of service has in fact been done. However, the email itself did not meet the mandatory requirement whereby it failed to state expressly the service of writ has been complied with the law of South Africa. In our view, we we are in the view that material fatal is concerning with the formalities of official certificates that are required by established law. Failure of such, they could deem no service of writ. Hence, we agree with Court of Appeal in setting aside the judgment in default. Secondly, pertaining to the issue delay in application by the appellants to set aside the judgment in default. This issue was discussed in High Court, and High Court apparently turned down the application of extension of time by the appellant, as it was apparently the appellant has exceeded the prescribed 30 days in filing such application. However, in Court of Appeal, it did not went further to discuss any issue relating to the stay delay. And the decision of Court of Appeal was a merit in appellant's case because it has setting aside the judgment in default so obtained by the respondent. And with that, we would like to cite the case of Tuan Haji Ahmed Abdul Rahman, whereby the court held that the court still retains discretion to set aside an irregular judgment despite there has been a long delay, provided that the court satisfied that such judgment would likely to cause oppression. And in regards to this issue, we opine that non-compliance of a mandatory requirement prescribed by the law is rather severe than a mere delay in application of setting aside the judgment in default, as the former could result in oppression on the aggravated party. It means that between the weight of non-compliance and a mere delay in application, we are agree with the Court of Appeal, saying that non-compliance of mandatory requirement would likely to cause the judgment in default so obtained was irregular, because judgment in default per se could not stand unless the service of writ was regular. And overall, we agree with the decision of Court of Appeal in setting aside the judgment in default, as there was no proof of service of writ. Hence, the judgment in default so obtained by the respondent was irregular. And with that, we end our presentations, and thank you.